Welcome to the Deep Dive. Today we are jumping into, well, the pretty intricate world of small and medium-sized enterprises, SMEs. And we're hitting the panic button on one specific, and let's be honest, almost unavoidable risk: cash flow disruption.
Yeah, and this isn't just, general economic jitters we're talking about. We're really zeroing in on a critical, sometimes catastrophic alarm scenario. Think about this. A crucial supplier, or maybe even worse, a long-standing valued customer you've given credit terms to for ages, suddenly defaults, stops paying.
Right. And for a business operating on, let's face it, often tight margins, that single missed payment, it can cause a whole cascade of problems, a systemic collapse almost.
That's the reality. It happens.
So our mission today, our deep dive, is to cut through some of the legal complexity. We want to extract the proactive, really essential steps you need to take. Steps to ensure your contracts aren't just, fancy pieces of paper. They need to be robust, enforceable financial shields.
Absolutely. And if you're listening and you manage an SME, this conversation directly impacts your business's viability, maybe even its survival. Businesses like yours often rely so heavily on the precise timing of income, of payments coming in. So if those receivables dry up, whether it's from a key debtor or even a partner you thought you could trust, well, the consequences can move incredibly fast, from just inconvenient to, like you said, truly catastrophic.
Which is exactly why we need to ensure that framework, the contractual framework holding your business together, is actually solid, rock solid.
Mm-hmm.
Okay, let's unpack the biggest danger zone first, which seems to be this assumption that your existing contracts are somehow bulletproof. We see this a lot, don't we? There's common oversight where businesses only really look closely at their agreements after a default has already happened.
Oh, definitely. It's like only checking your insurance policy after the house is burned down, isn't it? People just assume the terms they signed maybe 3-4 years ago are still perfectly valid, legally binding, especially if the relationship has been smooth sailing up until that point.
So what's the cold, hard legal reality then? When they finally dust off that contract, maybe because the payment is, say, 2 months late.
Well, the reality can be quite painful. If those contractual terms haven't been kept up to date or maybe weren't enforced correctly according to current laws, and this is crucial, your actual day-to-day trading practices, they might just not provide the legal muscle you need when you go to make a claim, that document you relied on. Suddenly, legally, it's kind of inert.
Wow. So the key takeaway right from the start is that being proactive isn't just, good governance checklist stuff. It's genuinely about building real financial resilience, protection against shocks. This can't be a reactive cleanup job after the fact.
Absolutely not. Think of it like preventative legal maintenance for your business. Doing regular assessments of your contracts, your obligations, your trading practices. It needs to be woven into the fabric of your standard operations, not just something you pull out of an emergency folder when things go wrong.
Okay, that perfectly sets up the most actionable part of our deep dive today. This is where it gets really interesting for our listeners. We've basically synthesized the research into 4 critical pillars. Think of it as a checklist to make sure your contract actually has teeth, real legal muscle.
Right.
Let's kick off with pillar 1, statutory compliance. Now, I know this sounds a bit dry, maybe even boring.
Yeah, it can sound that way.
But the implications here can instantly, vaporize your best enforcement efforts.
Oh, it's a huge trap. A really huge trap, especially for SMEs. Many small businesses, when they extend credit to customers, and this can even be other small businesses, B2B, they sometimes forget that certain consumer protection laws might actually apply, depending on where you operate, of course.
Hang on a second. Let me clarify. Say I'm a small manufacturer selling, widgets to a local construction company. That's B2B. Why would consumer law, like, for instance, the National Credit Act, potentially interfere there?
It's a great question. Because that specific type of legislation often sets certain thresholds. If you extend credit, maybe you allow 30, 60, 90 days for payment, and your customer is a smaller entity that happens to meet the Act's definition of a consumer, even if they're a business, you might, without realizing it, be acting as a credit provider under that law.
Oh, okay.
And failing to follow the rules of that act, like mandatory disclosures or, and this is a big one, doing a proper affordability assessment before you grant that credit. Well, that failure can completely nullify your standard trading terms.
Okay, so let's play that out. If I skip that affordability check, maybe because it seems like too much hassle for a regular customer, what's the worst case scenario when they default?
Well, the contract itself might still exist on paper, but your ability to enforce key parts of it could just vanish. Poof. You might lose the right to charge interest on the overdue amount, for example. Or, even worse, you might find a court refusing to uphold your attempt to reclaim goods or terminate the agreement based on non-payment.
That's serious.
It is. So the actionable step here is really concrete. You need to routinely do at least basic financial health checks. And, where applicable, proper affordability assessments before agreeing to any credit terms. You essentially need proof that your customer can legally take on that debt and repay it.
That feels like a massive hole many businesses could easily fall into without realizing. Okay, let's move to Pillar 2 then. Verifying authority. This seems more straightforward. It's about making sure the person signing the paper actually has the right to commit the company, right?
Exactly. This is fundamental company law, but again, easily overlooked in the rush of doing business. Remember, a company is its own legal person, separate from its owners or managers. A contract is only truly valid if the individual signing it on the company's behalf has the proper legal authority to do so. And that authority usually needs to be formally granted by the board of directors.
So if the agreement gets signed by, say, a mid-level manager, or even a CEO, but maybe without a specific documented permission for that particular deal,
then the contract's validity could definitely be challenged later on, especially if the deal goes sour.
Okay, so what exactly is this director's resolution you mentioned? And how does an SME, without a big legal team, actually verify this? It sounds complicated.
It doesn't have to be. A director's resolution is basically just a formal written record of a decision made by the company's board. It grants specific permission authority to a particular person, maybe the CEO or CFO, to enter into a certain type of contract or maybe contracts up to a certain value. The actionable step for your business, when you're the one receiving the signed contract, is pretty simple. Ask for it. When you enter into a significant agreement, politely request a copy of that resolution or at least a certified document confirming the signatory's authority. Keep it with the contract. Don't just assume that a fancy title on a business card equals the legal power to bind the company. Verify it.
Right. Get the proof. It's fascinating, actually, how these first two pillars, compliance and authority, really tie into the next ones. Because as the stakes get higher, maybe your credit facilities increase or payment terms get longer, the risk obviously goes up. Which means your vetting process needs to get sharper, doesn't it?
Precisely. You've got it. If we connect this to the bigger picture. Okay, so you've established that the person signing has the authority. Check. Now you need to be absolutely certain about who exactly they represent, which company. And that brings us neatly to Pillar 3, accurate counterparty identification.
Which sounds incredibly basic, right? Just get the name right on the form.
It should be basic. But you'd be amazed how often simple mistakes here can completely derail or destroy legitimate claims later. If you record an incorrect company name, maybe slightly misspelled, or you get the registration number wrong, or you use a trading as name instead of the actual registered legal entity name, well, any subsequent legal action becomes incredibly difficult. It causes delays, added costs, and sometimes cases just get thrown out on these technicalities.
Okay, so give us the vetting essentials here. What are the absolute non-negotiables we need to check?
Right, essentials. First, thoroughly check and record the full, correct, registered name and registration number of the company. Double-check it against the official company registry. Second, verify the identity of the directors. Are they who the company says they are? Third, confirm the registered office location. That's often where legal notices need to be sent. And fourth, maybe check the company's longevity and its current status. Is it active? Has it filed recent returns? These details are like the anchors for your potential legal claim. If you have the wrong details, it's like trying to sue a ghost.
Which leads perfectly into Pillar 4, which asks that fundamental question. Is this counterparty actually still a functioning entity?
Exactly. Pillar 4 is all about understanding the counterparty's status. Look, you could have a perfectly drafted contract signed by the right person with all the certified resolutions. But if the company you signed with is already, say, in liquidation or it's been deregistered from the official records, that contract is essentially worthless for recovering anything significant. You've basically signed an agreement with a defunct entity. It's an untenable situation.
Okay, can you quickly clarify the difference? You mentioned liquidated, deregistered, and maybe something like business rescue. They all sound bad, but are they different legally?
They are distinct, yes, and the implications for you as a creditor are different. Deregistration usually means the company has failed to keep up with administrative filings, like annual returns. It technically ceases to exist legally, like a ghost, as you said. Very hard to pursue. Liquidation is more formal. The company is officially declared insolvent, effectively dead. Its assets are frozen, and a liquidator is appointed to sell everything off and pay creditors according to a strict legal priority. You'll likely get pennies on the dollar, if anything, unless you have specific security. Business rescue, on the other hand, is an attempt to save the company. It's financially distressed, but trying to restructure and survive. Critically, while a company is in business rescue, there's usually a moratorium, a freeze on legal action by creditors like you. Your rights are restricted while they attempt the turnaround.
Wow, okay, so the actionable step here isn't just a one-off check at the start.
No, absolutely not. You really have to treat this as part of ongoing relationship management, especially for key customers or suppliers you offer credit to. It's not just about the initial onboarding form. You need regular, maybe light touch checks or investigations on your key partner status, just to avoid, signing a massive new credit deal with a company that's actually teetering on the brink of collapse or already halfway gone.
That checklist, compliance, authority, identification, status, that provides a really solid foundation before trouble hits. But inevitably, sometimes trouble does hit. And when it does, reacting with fear, or worse, paralysis, is the absolute worst thing you can do. You need a plan ready to go, a predetermined response. Let's talk about protocols for default and distress.
Yes. Establishing clear, sort of pre-agreed protocols for different payment scenarios is critical. It allows for a rapid, unemotional, consistent response. The moment a significant payment is missed, the SME needs to have predetermined actions ready to deploy. No dithering.
So what does that escalation ladder typically look like? What's the standard playbook?
Well, it should start pretty much immediately. First step. As soon as a payment threshold is breached, dispatch a formal letter of demand. This officially records the debt and often starts the clock ticking legally. Second, if you have any ongoing credit facilities open with them, meaning you're still supplying them on terms, you need to immediately convert those to cash on delivery or CO'd, or even cash up front. No more goods or services leave your door unless payment is received first. You have to stop extending them more credit instantly. Stop digging the hole deeper.
Makes sense. And if they still don't pay up after the demand letter and you switch to CO, legal action is the next step, right?
You have to be prepared for it, yes. And crucially, you need to be prepared to initiate that legal action promptly. Delaying legal action is probably the single biggest mistake SMEs make when facing a defaulting debtor who might be in serious trouble. Why? Because when a company is genuinely distressed, it often becomes a race among creditors. If you delay, you move further back in the queue, and by the time you get a judgment, there might be no assets left. Earlier, faster creditors or secured creditors like banks might have already claimed everything.
And I imagine this is exactly the point where trying to handle it all internally just doesn't cut it anymore. This is where outside expertise becomes non-negotiable, isn't it?
Oh, absolutely. The moment you see serious financial distress signals, not just a slightly late payment, but signs of real trouble, engaging legal counsel early is vital. It's not an expense, it's an investment in potentially recovering something.
Why specifically legal counsel at that stage?
Because distress proceedings, especially formal ones like business rescue or liquidation, are incredibly complex, legally technical processes. You need proper advice on how to correctly formulate and file your claim, how to navigate creditor meetings, which are crucial for influencing the process, how to vote effectively, and how to understand and protect your status, whether you're a secured or unsecured creditor.
So it's more than just filling out forms.
Much more. A good legal advisor doesn't just file papers. They represent your interests. They help you understand the process. They ensure your rights and claims are asserted and protected throughout what can be a really chaotic and frankly quite stressful process, like insolvency inquiries or negotiations with practitioners. It's really the ultimate defensive measure to maximize your chances of recovery when you're competing with other creditors for a limited pool of assets.
Okay. So if we synthesize everything we've covered today, wrapping this up, the core takeaway seems to be this fundamental shift. Away from just reacting when payments stop, towards constant anticipation and preparation.
That's exactly it. SMEs simply must proactively and regularly evaluate their contractual arrangements. They need to look at their enforceability, using those 4 pillars we discussed: compliance, authority, identification, status, and build these checks into their routine business health monitoring. It's this proactive stance that truly fortifies the business's overall health and, crucially, secures its working capital.
Right. Ultimately, these steps are about safeguarding your cash flow, securing your financial future by making absolutely sure your contracts actually hold tangible legal value when you need them most. So what does this all mean for you, the listener, tuning in today?
It means taking action now, not later.
Exactly. You spend critical time and energy vetting the financial health and legal authority of your partners and customers, focusing on pillars 2, 3, and 4 for them. But here's a final thought to maybe mull over. What about your own house? Since robust contracts require verified authority on both sides, have you considered auditing your own business structure recently? What assumption might you be making right now about your own internal compliance? Specifically, those director resolutions backing your own company's signatory authority. Could a gap there potentially nullify an otherwise perfect contract that your company signed? It's time to look inward. That internal vulnerability is often the easiest one to fix, but maybe the most overlooked. Something to think about. We'll see you on the next Deep Dive.